Hello there. In this module, we're going to cover boundary resolution. In all fairness, this is a deeper subject than one module. I didn't realize that when I made the syllabus. This lecture and PowerPoint presentation will be slightly abbreviated in content. Full content is in this week's PDF handout. So please read that in detail. Some of what you will need for the assignments in this course will be covered in greater detail in the handout. It may not be covered here. Same goes for test questions. So I'm going to give a lecture to try to introduce you to the topic, gain some understanding. It's up to you to read the material, absorb it, and apply it as we go further. Now, one reason I'm comfortable abbreviating the lecture is that we have case studies coming up in which we will be looking at how to apply the various theory and academia that we're going to cover in this module into real surveying scenarios, situations. So, as an introduction, boundary resolution is what makes land surveyors different from simple measurement takers, GIS professionals, and engineers who understand coordinate geometry. The term means that surveyors resolve boundary issues and form a defensible professional opinion of where the boundaries are situated. Applicable legal principles, state laws, evidence evaluation, and sometimes a sixth sense, which I will refer to, all converge in a process that is only partly mathematical. Now, those other folks, especially engineers in general, think that surveying is just math. It's just coordinate geometry. It's just an inverse between 2 points. It's just, I had an engineer say once, well, surveying is easy. Even I can do it. You go to the rebar, you look at the plat, you get the bearing of the distance, you put it on the ground, there's the property line. They fail to recognize meridians, confirming that that was actually the corner. What was the basis for the bearing on the plat? Lots of ways to make some really critical mistakes with that type of approach. Land surveyors are much more than mathematicians. We are detectives. We are quasi-legal experts at times. So, keep all this in mind as we go forward. What we're looking for as land surveyors is the most defensible solution. Some logics are more defensible than others. And by that I mean if we're trying to evaluate whether to hold a pin that we found or not, we have to put it through some tests. We have to try to defend it. If it's not all that defendable, we look for weaknesses. We'd like, I'd hate to have to defend that position. Maybe that pin's been moved, or maybe that pin means something else altogether. Maybe it's a grounding rod by a power pole. I saw more than one grounding rods by power poles held as property corners that made all kinds of problems. So the surveyor should consider all the evidence and possible solutions and go with the one that is the most defensible. That's all we can do. We're not perfect. We will not find the perfect solution, but we must be able and prepared to defend our solution. So we need the one that is the most defensible. Like in the quiz, I said, there may be more than one correct answer. You have to find the one that is the best answer. Or in a boundary resolution, it is the most defensible. So, how do we do that? There's a few steps. Had a hard time finding a place to start at first, or at least in the broad topic. But the very first and most important document that the surveyor should review in the boundary analysis is the vesting description for the property being surveyed. Now, as I've said before, we don't advocate for our property versus the neighbor's property, or for our neighbor, or our property versus the neighbor. We advocate for the boundary, wherever it may be. But our vesting description covers all of the lines that we are analyzing and defending. So we're going to start with our subject property and just read the deed. So what do I mean by read the deed? You've got to pay attention to what's in there. In the handout, I give an example, and I'll abbreviate. There was a piece of property, part of a land lot that lied on the north side of a county road. Gentleman had owned all of it. Okay. He conveyed a couple of acres on the east side between the north landlot line and the county road, which ran mostly east and west, without a survey. They knew roughly where it was going to go. He thought it was roughly 400 feet wide by 200 feet deep, so he said 2 acres more or less, beginning at the northeast corner of the land lot, thence west along the land lot line 400 feet to a point. Thence at a right angle, south 200 feet more or less to the county road, easterly along the county road to the east line of land lot blah, thence north to the point of beginning. Perfectly legal, non-ambiguous legal description. Somewhere, some point in time, nobody knew where, nobody was claiming it, but 398 feet from that landlocked corner was a pipe. I was a young surveyor. I was not even licensed at the time, but I found the pipe. I'd already been to college. I said, hey, monuments control over bearings and distances. I'm holding that pipe. We were surveying the remainder property, the property to the west. The attorney called and said, you're shorting the guy next door 2 feet. I said, no, I found an iron pin. Iron pin's control. He said, son, that pin has to be called for. And that's just a pipe in the ground. The guy next door's got 400 feet, not 398. You're giving us 2 feet that we don't have title for. Now, in the handout, I gave the hypothetical, what if a fence got built in that 2 foot line, in that 2 foot strip? Guess who would move it or pay to move it? The surveyor. You have to read the deed. Things like that, you just skim over it in a hurry, you make mistakes, you wind up with disputes and liability. And it can be easily prevented, which is what makes it negligence. Negligence means you're going to pay. So just slow down, read the deed, make sure that you're picking up on things. Besides just the description of the property, a lot of times there's some additional language in deeds. 3 things particular: exceptions, subject tos, and together withs. So often a large tract, you're surveying the remainder of a property where pieces have been conveyed off to businesses or to children, etc. Instead of getting a survey of the whole farm or the whole remainder, what they may do is say, I just want to sell it. Well, you don't have to have a new survey to sell that. Now in your mind, you may be thinking, how in the world do you sell, if it started out as 100 acres and there's been 5 pieces sold off, how do you sell it without a survey? Just think about what is conclusive and non-ambiguous. They're usually sold by the original description of the grantee before anything was sold off. And then it'll say, less and except property sold in deed book such and such, in deed book such and such, in deed book such and such. So in other words, it's saying, we're all this big piece of property, 200 acres, 20 acres, whatever it is, less and except these pieces. So that's what you're surveying is you take the parent tract as it was and you carve each of those off. It's fairly common. That's when tracts have been sold off in fee. Similar to an exception is when there has been some kind of easement or right conveyed away from a piece of property, and the footnote there is liable to say subject to an easement in deed book so-and-so, which may be for a gas pipeline, a driveway, a solar field, who knows? Power lines very common. It might also be subject to something that's not a survey matter, like a right of first refusal, a mortgage to the First National Bank of Dublin. These are things that affect title that need to be in the deed, but they're not things that surveyors need to necessarily know about. So you just have to read to find out. If it's subject to an easement for a gas line, wow, well, we overlooked that. We need to go back and look for that gas line because it's in the deed, you're on notice, it's an easement that covers the property, we're required to show it to DOT. Together with means the described property plus some other stuff. Now, sometimes it's additional tracts, but often an attorney is going to say that as, and also the following described property, or they'll have parcel 1, parcel 2, parcel 3, but not always. But usually when it's together with, then that is an easement that benefits the property. Like if it's not fronting a county road, the easement was acquired separately or later, or maybe there's two different easements, then it might say, together with those rights arising from a certain driveway easement in Deed Book 101. Or together with a scenic view easement. Perhaps, some properties are burdened by that, where they have sold off the right to build something in a certain area on their land so that a neighbor can enjoy the view of a golf course or of the Chattahoochee River or of the Atlanta skyline. So these are all things that would be subject tos. If it's something that's just, it might be that subject to covenants and restrictions, for a subdivision. Those are generally not survey matters, but it's things that affect the title. But an easement that benefits the property, that's essential to it especially, is something that surveyors need to know and call for, or cite and include. Sometimes there are just ambiguous, vague, or nebulous calls. Sometimes descriptions just don't make sense. If it's supposed to be an acre more or less, and it says thence due north 4,000 feet, thence west 100, well, that's probably 400 feet instead of 4,000, but sometimes you don't know. But we're confined to the four corners doctrine. We can't be imagining things or trying to get in the head of everybody conclusively. Now, sometimes we have to, but we qualify our decisions in indisputable language. But generally, we're confined to what's in the four corners of the deed. So if the deed calls for 4,000 feet, well, wow, you just have to address it. So the reason I bring this up is just to understand, sometimes these things don't make sense. Sometimes you have to scratch your heads. Sometimes they're just goofs, typos. Think about what a homonym is. I have seen homonyms for various property owners and features on the ground called for. I've seen, I saw one particular was it was called for a T model axle, and you think you could see it happen kind of with AI or some sort of voice recognition, but this went back. This was in the early days of cell phones, so it probably explains it. I won't say early days; it wasn't too many years ago. But the deed, which was a non-surveyed meets and bounds description for a piece of property in a rural area, trying to save money, I get it. Instead of to a T model axle, they wrote down a T-mobile activity. It made sense in a way, but it didn't really make sense as a property description. So when these ambiguous, vague, or nebulous calls come along, you just have to deal with them one at a time, figure out what to do with them. And I also say this, it's a little bit out of turn, but just like with field procedures, which was covered in the last module, boundary analysis, there's no substitute for experience. There are so many things, I've been doing this for 38 years now. I still see things for the first time. I'm still learning, still seeing things that I'd never seen before. I always wondered what they meant, and I'm finding out now. So there's no substitute for experience. Boundary resolution and being a boundary surveyor is something that's really hard to do, in my opinion, like on a part-time or occasional basis. And I know a lot of retired surveyors who've told me that going back to try to resolve a boundary or figure something out once or twice a month is they feel very uncomfortable. So when we're trying to resolve our boundary, and we're trying to figure out how to compare and analyze all this, we have to have some rules, have to have some knowledge, we have to know what we're doing. That's what we're going to start covering now. So in general, the hierarchy for boundary control, this is found in most every textbook, code section, sometimes court rulings. Number one, the most high control is natural objects such as streams, rock outcroppings, and trees, because they're less likely to be moved or counterfeited. Of course, a stream is a riparian boundary, which brings its own flavor of law. But if the stream location hasn't changed and you're trying to determine a boundary on the opposite side of the property from a stream, if there's no evidence that the stream changed, then that puts a lot more weight in a measurement from that stream, for example. A tree, it's not too hard to pick a rebar up, go over a few feet and stick it back in the ground and make it look like it's been there for years, unfortunately. And if you surveyed much, you probably found that situation. But it's really hard to move a blaze 24-inch red oak. So that's why they have the highest controlling hierarchy. Now, I have saw a description that said north 200 yards more or less to a certain poplar tree. And when you went in a northerly direction, 600 feet, you wind up in a grove of poplar trees. And there was no particular poplar tree that was distinct or obviously held as the corner. And so you wind up with an ambiguous, even with a high hierarchy call. Secondly, it would be artificial monuments such as iron pipes, concrete monuments, fences, anything that's called for that's artificial. Trees, rocks, and streams, they're natural. Although rocks can be placed, but this is, number one is a rock outcropping. So I would say that, kind of a hybrid of that would be a placed stone where the location is artificial, but the material is not. Third, after these artificial monuments are measurements, also known as course and distance. Course meaning a bearing. Sometimes a course means a bearing and a distance, but measurements, they fall down pretty quickly outside of things that we find on the ground. Measurements are usually last resorted to, but the lowest controlling hierarchy is area. So if the deed says being 5.7 acres more or less, and it winds up being 3 acres, well, tough. If you follow the description and you found the boundary, the acreage means the least. It's one reason why almost, or hopefully every deed or legal description will say containing X amount of land, whether it's square feet or acres, more or less, because title law does not get tripped up on area. Area is not insured in title policies. If you come up with less acreage, that's okay. They just go by the description of what you have insured. In the process of our analysis, we have to think about meridians. North doesn't mean the same thing every time that you see it. North is what your coordinates are based on, what that due north line, those north lines in your grid, in your imaginary grid on your coordinate plane, are oriented to. Is it just north based on a compass? That's good, but it's not real good, at least you know. A magnetic north, especially in the southeast, generally means that somebody had a pocket compass or maybe a really good compass, and they took a reading between their first 2 points of their survey, and everything else is rotated to that line as being whatever the pocket compass was. Now, you won't have bearings to the nearest, exact degrees, minutes, and seconds of 0 anywhere necessarily, but you will on the first traverse line. That's usually what we would do, is take a compass bearing on our starting point to our next traverse point, and that's what the whole job would be situated to. Now, you may rotate it to a reference north, where we've rotated everything on the survey to where the bearing of the common line of our survey and their survey matches, and so our meridian is a reference north that would reference their survey. And there's board rules for that. That shows that, requires that we show where the bearing basis is. In other words, if we put on our plat the north arrow is a reference north, Plat Book 17, page 193, then we need to show on the plat which line is the bearing basis. And so whatever the bearing is on our plat, there in that situation would be the same bearing that is on Plat Book 17, page 193 for that line. The more common scheme as time goes on is grid north. Why? Because the job's been oriented to GPS. And by doing that, the meridian is repeatable. We can come back to it. We know what it is. We're automatically tied into a job with one pin if it's not been moved and it checks out, because we're already rotated. So, a very common issue that I've seen is a difference in bearings on the same lines from plat of one property to the adjacent property. Let's say that they're different. Let's say that one, is, and I'll exaggerate, is northeast 12 degrees. And then the same bearing or the same line on the adjacent plat is 5 degrees northwest. So that's 17 degrees difference. An attorney who knows something about math is going to look at that and say, we have a 17-degree difference. We have a core, or we have an overlap. You know, this can't be right. The bearings should be the same. This property does not match up. We have a title problem. We have a dispute. It may just be that both people's compasses, the needle is off a few degrees. Possibly all that means. If it's the same corners at each end of those lines, then there is no dispute. There's just a difference in meridian. So don't get tripped up on meridians. Don't make the mistake if you're building a job in as you traverse or as you prepare in the field and making an ASCII file. Don't use the same bearing. You've got to figure out how you're rotated, and it just becomes an angular relationship. Think about the interior angle or the exterior angle of two lines that intersect, not what that bearing is. That bearing will fool you. Something else that we have to think about is the law of significant digits. If you don't know what this is and you're not familiar with it, internet search it and spend 5 or 10 minutes on it. Basically, I summarize it as any number to the right of an integer that is 0 does not count towards the number of significant digits. It means that we don't know that it's any more accurate. So example, 8,000,000, 8,000,000, has one significant digit. That's 8. Now, let's say that for whatever reason, we have high certainty that a number is 8,000,001, 8,000,001, and that's a good firm number. Well, that has 7 significant digits. The zeros in between the integers count. A decimal basically factors in as well, because anything to the right of a decimal is assumed to be significant. Significant means it's reliable, it's been measured, it's what we contend with. So, you know, there's this joke that I remember from my childhood where a museum worker is given a tour and he says, this fossil is 8,000,001 years old. And somebody in the tour says, little Johnny, how do you know it's 8,000,001 years old? He says, well, when I started work here last year, it was 8,000,000 years old. Well, see, that's a flaw. That's an error. It's still 8,000,000 years old because your plus or minus rounding rules apply. Your plus or minus the value of one of your significant digits. So 8,000,000, think about it like 8 bananas, 8 pounds, 8 feet, somewhere between 7.5 and 8.5. So you're between your plus or minus 500,000 years when you say 8,000,000 years. The reason this is important is this applies to surveying, to retracement of especially old descriptions. If a deed says north 400 feet, more or less, to a poplar tree, there's one significant digit and it's 4. That means you're within 3.5 and 4.5, or you're between 350 feet and 450 feet. So if you find a monument that looks good at 368 feet, you're well within the tolerances when you properly apply the law of significant digits. Do not make the mistake of inventing data and assuming that that's 400.000 feet. If you don't find something out there, you go set a pin 400.00 feet, there's no way you're setting it in the right place. It may wind up being the most defensible solution after a thorough analysis of all the different options, but more than likely, that's not the case. So you've got to think about that. There's also, it also applies to bearings. If the deed says north 12 degrees east, that's somewhere between 11.5 and 12.5 degrees. It does not mean 12 degrees, 00 minutes, 00 seconds. Do not invent significant digits that do not exist. Surveyors also have an added level of law of significant digit cognizance required of us, because some of our older surveyors in days gone by wouldn't tell us exactly what they were using or how they were measuring. A lot of bearings that are out there are to the nearest 15 minutes. And you have to look at a deed in its totality and say, oh, this is north 32 degrees, 15 minutes east. Then the next one is south 44 degrees east. Maybe it's to the nearest degree. It's also to the nearest quarter degree. Then another call might be to the nearest 30 minutes, and then 15 minutes, and then 45 minutes. You have to pick up on the fact that that was probably done with a 1/4 degree or 15-minute transit. So it's not very precise. You really have to dial out and think, okay, that's really, a call for 15 minutes really means that's between 7.5 and 22.5 minutes. Anything in there is well within the tolerance when you properly apply the law of significant digits. You can also look at the same thing on distances. 175 feet may seem like it has 3 significant digits, which it does. But if all the distances in a description just happen to be to the nearest 25 feet, you have to realize that you have an alternative law of significant digits right here. Your distances are to the nearest 25 feet. So, if 175 foot call winds up being somewhere between 162 and a half and 187 and a half, and you're still within the nearest 25 feet. So again, don't invent precision or significant digits that don't exist. It can really trip up your boundary analysis, and you'll wind up putting a pin in the wrong place or holding a pin that somebody else put in the wrong place, which is bad because then you're assuming responsibility for their mistake. There are some other flavors that we have to consider when we're resolving boundaries. Some conveyances are called simultaneous conveyances, even though they're not really simultaneous. What it really means is that when a subdivision plat, which can show 50 lots or 2 lots, when a plat shows a parent tract or a portion of a parent tract divided into 2 or more lots, and it's put on record for the purpose of selling those lots or conveying the streets or the common areas, etc., then all of those parcels are considered to have been created simultaneously. So even though they might sell lot number 1 and then lot number 20 and then go in between, they all have the same weight and are not subject to sequential conveyance rules, which we'll cover in a minute. Now, what does this mean? Well, one thing that's important to know is when in a simultaneous conveyance, a subdivision plat like this, if it shows street right-of-ways, if it shows common areas, all these things are meant to apply equally and benefit equally every lot that's shown. So if there's a street right-of-way on a subdivision plat, when the very first lot is sold, that lot has an easement over all the roads, all the easements, all the common areas shown, or potentially a common interest or a proportionately similar interest to all the lots in those common areas. So that's a legal issue that we don't really get into a whole lot. But what we do get into that is unique to simultaneous conveyances is proportioning. You may hear this by other terms such as apportioning, proration, or proportionment. So it's the process of distributing excess or deficiencies in measurements between original monuments. So proportioning applies only to simultaneous conveyances, most commonly subdivision plats. Because of the mathematical simplicity, it is taught and used far more than it is actually applied. So typical example, say, and this would be odd, but let's say that a block is supposed to be 500 feet long from street to street, and there's 5 lots that are all supposed to be 100 feet wide, and you actually go measure the block and you find the block corners and they're 500 feet apart. Well, each of those lots gains proportionately and is 101 feet wide now. But if it's 495, they all shrink and now they're 99 feet wide. That's what happens in a simultaneous conveyance, where each of those lots has the same legal weight in their title. So this can have this is often misapplied. The biggest error that you can do with this, pay attention, is to apply apportionment to corners that are not original monuments. Sometimes you have to in a way, but when you do, that might be what you do, yet you still call for a boundary line agreement or some kind of title remedy. Proportionment is often misused, misapplied, and it should only be used as a last resort. Now, on the opposite side of the coin from a sequential conveyance, from a simultaneous conveyance is a sequential conveyance, meaning it is a series or a sequence of events, a sequence of conveyances. And this, by virtue of how it is done, creates junior-senior rights or senior-junior rights. So sequential conveyances are made when a tract of land is subdivided one tract at a time using an individual or unique legal description or plat. In this situation, the highest control of establishing the boundary of either the remainder or a subsequent tract or the original tract, it really doesn't matter. But when you got a missing corner, you have to put it back. The first thing you got to do is decide, are you in a sequential conveyance scenario or a simultaneous conveyance scenario? Because you'll use proportioning potentially in a simultaneous conveyance scenario, but if you're not, then you fall back on junior-senior rights. So your highest control is the exterior boundary of the original or parent tract. Next are the boundaries of the parcels conveyed out in sequential order. So the very first tract that comes out is senior to everything, to the remainder of the parcel and to any other tract that's sold off the parcel. It gets everything that it's called for, unless that overlaps onto an adjacent property. But it gets everything that the grantor had to sell. Because if the grantor doesn't own it, they can't sell it. So if it overlaps the adjacent property, that doesn't count. But within the confines of the exterior boundary of the parent tract, everything that's in that senior deed, the senior deed gets. Subsequent conveyances of portions or the remainder of the parent tract are junior, as in younger. Junior conveyances also get everything described as long as the grantor had it to convey. But if the junior conveyance includes, by mistake or whatever, land that was already conveyed to a previous out conveyance that is senior to it, then the senior conveyance controls. There is really no overlap because the original grantor conveyed it first. He or his successors didn't own it to convey a second time. So you can't sell the same property twice. So the one that's senior, the one that's in line first, gets it. If he accidentally conveys it later by virtue of some choppy legal description or survey that overlaps it in place, the overlap is absorbed and dissolved by senior rights. We probably should depict that in a dashed line and explain this is the boundary as described in so-and-so, junior to senior conveyance in deed book, blah, blah, blah. That's exactly how I address that. Another example would be, say for example, piece of property is supposed to be 500 feet wide, and somebody sells off the eastern 300 feet of it. As the description comes down, 300 feet along the road, blah. So then naturally, when they sell the remainder of it, they say 200 feet wide, because my deed says 500 feet more or less. I stepped it off. It looks like 500 feet. Yay, we're good. What if there was only 498 feet to convey? And the first piece was accurately surveyed and there's a pin sitting at 300 feet. That means there's only 198 feet left. That means the junior conveyance only got 198 feet. Yes, his deed says 200. Too bad, so sad. That eastern 2-foot strip was already conveyed to the senior conveyance. The grantor did not own it any longer. He couldn't sell it twice. The deed said 200 feet, but all he actually conveyed was the 198 that he had. Got to think about that. So we get into gores and overlaps. When you've got a simple application of junior-senior rights that's easily wrap your head around and can make sense out of, then often we can resolve those overlaps. But that's actually rare. Most of the time, we don't know the history. It's really not in our purview to run back 17 conveyances to see who's junior and senior. And even then, if you did, you're going to get into all kinds of different older versions of the legal descriptions that may create more questions or problems than solve them. Sometimes you've got two pins 5 feet apart. One property is calling for one, another property is calling for another. If they don't match up, there's a gore. It's no man's land. You need to show it, and you need to show the plat on the adjacent property. There's a triangular piece of property, a parent gore, not included in the eastern adjoiner's description or the western adjoiner's description. That's how you describe it. You can't just claim it. Some people think that, oh, there's a gore, I'm going to claim it, I get it first. Well, from a title law standpoint, legally, that's not quite the case. It's not that simple. If they overlap, then there you go. it's our duty to show them, not necessarily to figure them out or spend an extra 2 days in the courthouse digging. We are required to show the overlap. If the client wants to engage us for additional work to go to the courthouse for 2 days, that's fine. That's really not expected. That's beyond the pale of what would be expected. We've done our job when we read the adjacent description and we find the evidence in the field and we say, here's an overlap. Then it's up to the client to decide how to address it. To this point, correctly and accurately identifying and locating such areas on your plats in your boundary analysis is a requirement of most state board rules, most especially Georgia's, as well as Alta NSPS land title surveys. So some people seem to think that they can ignore gores and overlaps. It's just creating problems that don't exist. No, you don't really have that choice. We're going to talk about some monument doctrine. Do you hold that iron pin that you found? Is it a rebar? Is it an open top pipe? You know, oh my gosh, do we set one, hopefully not very near it? That's pin farming. We'll get to that. But just roll through what I call monument doctrine. The doctrine that we apply and whether or not we hold a monument that we have found. In order to be controlling, a found monument should be called for, match the description, and be apparently undisturbed. What does that mean? If the deed calls for a 1-inch open top pipe and you find a 1/2-inch rebar, it's not called for. You didn't find the same monument. You may wind up deciding to hold that rebar, but your initial analysis right here, your litmus test fails because you're looking for a 1-inch open top. You found a 1/2-inch rebar. That's a problem. We hope that the rebar was set in that open top pipe because it was rusting and rotting away, but if we don't know, we don't know. In other words, if somebody has resurveyed the property and they say 1/2-inch rebar set at remains of rusted, crumbling, deteriorated 1-inch open top pipe, now the rebar is called for, and that marries together our description that calls for the open top pipe and the adjacent description that calls for the 1/2-inch rebar, which was set at the open top pipe. And it ties right into matching the description. You know, I should have clarified, you know, if it says to a rock, and you find a pin, the pin's not called for regardless of the description. You know, I went to the second point first. Or in that other example, if the deed says a point, maybe that's a position that's established by measurement. I hate that. It's rare. We don't want to go measurements over monuments, but pin has to be called for to be controlling. We can't just say, oh, we're going to use this tree because it looks good and Farmer John said it was. It has to be called for. Or we have to explain in indisputable language why. And it has to be apparently undisturbed. If it's laying flat, don't say here's the corner. If it's been mangled and flipped around and you have to dig it up, you know, bush hog got it, a road grader got it, lawnmower got it, and you just happen to find it, then it is not past the test of being apparently undisturbed. Also going to talk a minute about monuments that were set by previous surveyors. They should be held if they were set in good faith and in accordance with the standard of care of the day. So what do I mean by that? Let's say 100 years ago, the standard care of the day in a rural area was to take a compass and a 66-foot gunner's chain, and that's what you measured by, slope measuring along the ground. Well, if you find a pipe that was set 100 years ago by a surveyor using those measurements, that's great. Your bearing is going to be 1 to 10 degrees different. The distance that you measure precisely with modern equipment is going to be a lot shorter, usually. You hold that monument. It was set by a previous surveyor in good faith using the standard of care of the day. You have to kind of refine that. If it was, you know, done with a 1/4 minute transit and a steel tape, take that into account. If the deed says 400 feet to an iron pin and it's 398, I know I'm using that same scenario again, but let's say that the pin's actually called for and it's actually 398 feet, but you find out that that pin was set by somebody using a builder's transit and a cloth carpenter's tape. Well, 398 feet is probably pretty good. That's the pin that's called for in the deed. I don't care if it's 2 feet short. That's the pin that's called for in the deed. You have to take the standard of care of the day into account when you're retracing a boundary. Another thing that creates a lot of problems, most common scenario of problem is when a subdivision backs into a straight line. And let's say that those pins are not perfectly on a straight line. They're never going to be. They're going to be off a little bit. When analyzing a monument found along a longer line, you must evaluate it with sound legal descriptions. If it's not called for anywhere, it may be nothing more than a piece of metal. Even if some surveyor has set it as a point on line, if it's not called for, it's not called for. You don't have to hold it. If an adjacent description does call for the monument, you have to evaluate it, and it's either held or not. And it's okay to bend on these pins if they were set in good faith by a surveyor using the standard of care of the day. Modern surveyors, I think if we found a pin within a tenth of a line or so, maybe a tenth and a half, just depending, maybe more depending on the equipment used, I'm going to hold it, even if it puts a bend in that longer line. Just because our deed calls for 1,000-foot straight line, if that line has monuments along it that need to be occupied, need to be recognized and held, then you're going to have calls along every pin. And you just deal with it. And if not held, just calling the monument offline is generally not sufficient. So if you've got this north and south line and you've got subdivision lot lines butting into it, and you say, oh, half-inch rebar found 0.7 east or 0.3 west, that's not good enough. There's a subdivision plat where that pin came from. Somebody thinks that's their corner. It's evidence on the ground. Now, I don't recommend showing, just say there's 10 lots along this 1,000-foot line. I don't recommend showing 10 gores and overlaps with calls and acreages computed. So I say, hold them. If it makes sense like that, hold those pins. If you just say 7/10 east, actually what you're doing is you're failing to report and reflect a gore, because you're saying my straight line controls. This pin is offline, I'm disregarding it. It's not anybody's corner, it's just a piece of metal, 7/10 off the line over there, like it or lump it. No, somebody thinks that that's their corner. Their survey calls for it probably. Well, let's assume that it does through your analysis. Well, then you've got a gore. So you either go over there and hold that pin, or you create a situation where there's a gore you didn't report and a big old question as to, who does it? What's west? What's there? The bigger problem is when that pin's 7/10 west over on your property and you say, oh, 7/10 west, I'm not recognizing that pin because my measurements are better than the surveyor's measurements who set that pin. He was just wrong back in 1975. I'm much better today. My measurements are a whole lot better. His pin is 7/10 of a foot in the wrong place. Well, I can tell you from experience that's not going to work in court. Not going to work with your client, not going to work with the neighbor for sure, and it won't work with the state board. You've failed either to reflect an overlap that needs to be handled, which would be, somebody says, I've got a 7/10 of a foot wide overlap that you're making me deal with. It's worth $118 worth of property, and I've already spent more than that with you and the attorney trying to figure this out. They're not going to be happy with that. And think about it like this. Pin was set in 1975, 6,700 feet west of the line, west of a straight line. Then you take 12 jurors and a judge out there. Are they going to go with your imaginary calc point, 6,700s from this rebar or this 1-inch pipe sitting there with 5 colors of flagging all over it, faded? No, obviously not. So we're going to talk for a minute about some rules that actually reflect back into that. Now, I'm skipping over the part about Riley versus Griffin. Please read that. That case is a cornerstone in Georgia boundary doctrine. It's been referenced in a lot of cases. This code section was actually, I say, inadvertently removed from the code in 2012, but it's been used in a lot of court cases. It's been taught for a lot of years, a lot of surveying classes, and even with the code section to back it up as a statute, it's still what I would consider very authoritative rules for boundary location in Georgia, or almost any colonial state. Number 1, natural landmarks being less liable to change and not capable of counterfeiting shall be the most conclusive evidence. Think about that. The number 1 in our hierarchy is natural objects. Number 2, ancient or genuine landmarks such as corner stations or marked trees, in other words, artificial evidence left behind by a surveyor. shall control the course and distance called for by the survey. So the monuments control, not the distance called for by the survey. So if the survey says it's 1,200 feet, but the actual landmarks are 1,190 feet apart, well, that 10 feet never existed. You're now controlled to be 1,190. And falling back on what I was just talking about, that established subdivision line where those pins are not in a straight line. Number 3, if the corners are established and the lines are not marked, a straight line as required by the plat, in other words, what you're going by, shall be run. But an established marked line, though crooked, shall not be overruled. So if you say that rebar is 0.67 west, and that's in context with the other pins, like there's a little bit of a bow in the old surveyor's line due to the equipment he was using or his adjustment method, etc. And that's an established marked line, that pipe there at that 1974 lot corner that you're disregarding. Well, number 3 right here is going to be what shuts the door in your face. An established marked line, though crooked, shall not be overruled. Now, this part of the code section, in all likelihood, was calling for original markings by the original surveyors, like the original district surveyors in the 1800s or the original grant surveyors in the 1700s. But that same doctrine applies today to retracing and looking at existing boundaries. Georgia Code didn't even recognize area. It's not even on the sphere of hierarchy under the established Georgia doctrine. But number 4, courses and distances shall be resorted to in the absence of higher evidence. So if you have higher evidence, blazings on trees, pins, an adjacent survey, if you have some higher evidence, that controls where your corners go. But if there's just nothing else at all, the last resort are the bearings and distances that you got. And on that mark, don't think that your math is better than the other surveyor's math and go drive a pin in close proximity to another one. We're talking about a most defensible solution, a rebar in the ground, even if you would have set it 2/10 away. And you can get on social media, Life of a Farmer, Life of a Surveyor, you can find pictures of where people have drove pins next to pins on top of pins and even through rebar caps. It is, I'll use the word, it is retarded. Makes surveyors look like all of us are just retarded. There is no reason to do that. Maybe a 1/10 or 2 in a very high precision, multi-million-dollar high-rise downtown building lot, you might feel it necessary to disregard a monument and say that it's 1700 southeast or something like that. But do not create these multiple positions. You walk out there, the PK nail on the sidewalk is what everybody's going to see, not your imaginary calc point 1700ths of a foot away. I'm sorry, don't be retarded. But definitely don't set up another PK nail 1700ths away. Or on this old subdivision line, 6700ths of a foot away. Go back to that other rule. If a monument was set in good faith by a surveyor previously in accordance with the standard of care of the time, hold that monument. Don't set a new one a few tenths away and make us all look bad. Another subject that comes up a lot, encroachments. Encroachment and trespass are both legal terms. They're not truly surveying terms. People think they are. They're not. Both terms indicate a willful or accidental use of one person's property by another without their permission. Trespass, encroachment, same thing. Think about that. Land surveyors are usually not privy to any agreements or intents of the individuals or the parties, except for what they can personally observe while they're on the property. So, to call something an encroachment is to express a legal opinion, and it implies that the surveyor is privy to facts that are outside of our scope. So if we say that fence encroaches, now maybe it's obviously lot 5's fence and we're surveying lot 4 and that fence is over the line on lot 4. To say that it encroaches is to say that we know that the owner of lot 5 willfully and without any remorse came over on lot 4's property and built that fence. And by gosh, it's an encroachment and a trespass. The two terms are virtually interchangeable. Well, what if the same person owned lot 4 and 5 at one time and they built the fence and the fence was built on their property because they owned lot 5 or lot 4 at the time? Is that encroachment? Was it placed, willfully on somebody else's property? No, it was willfully placed on the same person's property. Then they decided to sell lot 4. That's their right. Doesn't mean that fence is a trespass. It means it's over on lot 4. Needs to be addressed. But if you called it an encroachment, the guy says, no, that's not an encroachment. I used to own that lot. I built that fence. Then you've just been disproven from something, a statement that you voluntarily made that you didn't have to. Some attorneys, some ALTA processors will beat you up wanting a schedule of encroachments. Read the ALTA standards. They say, without expressing a legal opinion, all possible encroachments. It's totally fine to say fence 2 feet west of line, 12 feet west of line, or whatever, but unless you know the people that were there and saw the fence going in the ground, you can't say it was a trespass or an encroachment because you don't have true knowledge of it. There's 2 other examples that can come up a lot that I want to touch on real quick on encroachments. One is 2 fairly sized, 5 or 10 acre tracts were surveyed. The adjacent property's fence is like 15 feet over the line. Oh, it's an encroachment. Surveyor says fence, 15-foot encroachment. Boom. Closing gets put on hold. The attorney's like, oh, what do we do with this? We can't insure over that. The bank doesn't want to insure property that's got an encroachment on it. Gee, this is terrible. What do we do? Come to find out, the adjacent owner was approached by the seller of the subject property years ago when they had a child that was showing livestock in FFA. This is down in Monroe County. They went to the guy next door and said, our land's kind of swampy. There's lots of rocks. Yours has been cleared. It used to be a pasture. Would you mind if we came over on your property a few feet and built this pen for our show goats? And the man said, oh, absolutely. I'd love to see them. Anything I can do to help. Now, was that a trespass? Was that somebody using someone else's property without their permission? No, it was with their permission. Now it's a license. It's a permission granted. It's not without permission. It's not an encroachment at all. The surveyor simply should have said fence 12 feet west of property line and let them figure it out if it's a problem or not. He made a statement that he couldn't back up when he called it an encroachment. It was a permissive use. Once they established that, oh, well, okay, well, that's great. We're okay with it now. We're recognizing that the fence is a license by the adjacent owner and not an adverse possession scenario. So be thoughtful of what we're, the ramifications of what we say and do. So putting all this together, the retracing surveyor is a detective, a gatherer of facts, an analyst, a scientist, and an artist of sorts. I left out attorney. Basically, we're quasi-attorney, a legal expert of sort. We have to understand and apply the law to a greater depth than a lot of law enforcement officers who are not lawyers. Academia can only teach you so much. To adequately learn the art of surveying, and I say art because boundary resolution is an art and not a science. It really requires several years of the very best teacher, which is experience. And we're going through the proper evaluation of field evidence, proper application of legal principles, all to determine the boundary location. It must be consistently in a surveyor's mind that every surveyor should be conducted as if it is known to be contested in court. There is an old adage that says to treat each survey as if you know it is contested and going to court, because if you don't, it just might. Some guidance for boundary analysis, how you actually do it. We've talked a lot about all these doctrines and legal aspects and all these things. When you get it all done, you've taken your measurements, you've adjusted your traverse, you've processed and scaled your GPS data. Here's your subject property. It's a 4-sided subdivision lot, or it's a 37-sided farm tract in middle Georgia. Start somewhere on that boundary. Analyze each line in a clockwise direction. I say clockwise just so that you're consistent. There's nothing wrong with going counterclockwise, but go in a consistent direction. Compare the monuments found versus monuments called for. That's just applying monument doctrine. We've been there. Analyze the bearings and distances or the positional relationship versus the evidence found and versus the description on both sides. You go back to your predetermined analysis from your research and you look at, okay, I'm supposed to have this bearing a distance to a 1-inch pipe. I'm supposed to have this bearing a distance to a 1-inch pipe. Wow, my bearing a distance is pretty close. Don't get tripped up by meridians. You got to account for that. And compare it versus fences and hedgerows and rocks and mow lines. If you're not certain about a pin, or if there's no good way to confirm the position of a pin, say that it says north 700 feet more or less to an axle, fence east to the road. You don't have a distance to the road, so you don't have anything more than in a northerly direction and a distance that has one significant digit to confirm that point. So if you find a pipe out there, well, maybe you found it, but you don't really have enough information to confirm it. If there's a fence and a timber line and a mow line and a potato patch that all recognize a line that goes somewhere besides that pin, you need to go over there and look, because those people probably set up their possession lines based on where they knew the corner was before it got tore out of the ground. Maybe it was innocently tore out of the ground by bush hogging or kids playing that didn't know what they were doing. I saw a Forestry Service monument get misplaced like 17 feet one time because there was a forest fire. Fire plow tore it out of the ground. Somebody realized what it was, got scared, stuck it back in the ground where they could get it in the ground because it was rocky. And they put it in the wrong place 17 feet. They thought the government needed a corner put up. But then the evidence, there was painted tree lines that went to where that monument was before the forest fire. So you have to analyze all these things. Go one line at a time. I plot them out on a piece of paper often. I make notes, I make scribbles, I look at it. I plot it to a scale. Often I'll pull out my engineer scale and scale around, or I may inverse, or I may try drawing a polyline on my CAD file to see how long something is, to get a good feel for how everything's fitting. Hopefully they fit, sometimes they don't. Then you got gores or overlaps or ambiguous lines. You have to put qualifying indisputable language on there. You have to show the evidence of possession along the lines. You have to show these fences and rock walls, retaining walls, mow lines, evidence of cultivation and whatnot. And finally, we'll touch on the topic of suggesting remedies when everything doesn't work out. We hope that everything fits and there are no issues and everything's just lovely, but sometimes they're not. Or sometimes our most defensible solution is not as defensible as we would like it to be. I feel good about that pipe that I found, but the guy's plat next door says it's supposed to be 400 feet over there and it's only 380. So potentially he could come over there and say, I've got 20 more feet. If you don't put some qualifying language on a plat, you are without qualification saying this is where the line is, and you will defend it with your license, and you will help the title insurance company defend that line if the court case comes up, and if you lose, you may be paying for the damages. So if you don't feel that certain in a line, address it. Put that indisputable language on it. Maybe you feel good about it and you think it's good, but you need to put somebody on notice. Maybe you explain adjacent deed calls for 380, measured it, or calls for 400, measured equals 380. Or maybe you just want to put a note on there, boundary line agreement recommended with Smith. Smith's deed is vague and cannot be confirmed to be in total conformity with subject property. Something like that. There are reasons that you need to suggest a remedy. Sometimes how you suggest a remedy helps an attorney understand the situation. If you word it like that, due to vague language in Smith's deed, boundary line agreement recommended with Smith, because you can't correlate the predetermined analysis with the field evidence and say, oh, we're in conformity. Where it's 985 feet on one plat from an axle to a iron pipe, and the next plat over has got a similar bearing that rotates out okay, and it's only a half a foot difference, and you find a pin pretty close to one of those that matches the description. There's no need for any qualifying language. There's nothing that needs to be remedied. But where you've got things that don't match up, that don't conform, you've got to address and put people on notice. And often a good way to address it is to recommend a remedy. You may be looking at the deed, you may be looking at the evidence on the ground and the surrounding properties descriptions and realize that there's a half an acre here that I can't really account for. My deed gets so far, and then it goes to the northeast to the creek. The fence, the possession line, and all the neighbor survey, it goes an extra 100 feet to the west to this rock that's not even in my deed, but it's obviously my property. Maybe the client walked you around and said, yeah, now it goes from this axle to this rock over here, 150 feet. Well, you're on notice that the client thinks it's his. You can't really disregard it. You need to put it out there. Maybe you chop that off and call it a unaccounted for tract or a gore. Maybe it's a title gore, but not really a gore in the premises because your client's been cultivating it or grazing livestock on it for years, thinks it's his. Everybody else thinks it's his, but if it's not in there, then you might just draw a dash line and say this area not contained within the description in Deed Book 400, page 123. Title opinion needed. Legal counsel recommended. Something like that. You just need to put them on notice that everything does not conform, because if you don't, you're giving them, the certification we put on plats that we've met all the board rules means that we've done a predetermined analysis, an accurate survey, a proper boundary analysis, and if we didn't qualify it or put some kind of explanatory indisputable note on there, then we're saying everything's fine. So keep that in mind. This is a quick overview, took an hour to cover, could have spent 2 hours or more covering it in greater depth. We will, through the case studies and the examples that we get to, and hopefully applying it and seeing what this means in practical application will help you to be able to learn what this means and learn these skills necessary for a professional land surveyor. Thank you.